Hello friends, today our subject of discussion is right to free legal aid of the disabled people and judicial response to their problem. To start with, among the various rights in the modern legal world, the right to free legal aid has been considered to be very important, as the concept of free legal aid is basic right of a democratic country. India is a sovereign, socialist, secular, democratic republic, ensuring social justice to all. Justice is administered in the courts. Access to justice is expensive and poverty may stand in the way. So, providing legal aid to the poor is the necessary result of the Indian system of rendering justice to all, irrespective of the consideration of rich or poor. The idea of legal aid included the rendering of any service in the conduct of a legal proceeding before any court, authority or tribunal, and giving of legal advice on a legal matter, and this service of legal aid is provided by way of providing advocates at the state expense, paying court fee on behalf of the eligible persons, bearing expenses regarding preparation of documents, paying expenses for summoning of witnesses, and paying other incidental expenses connected with litigation. The relevancy of the free legal aid in the case of disabled people arises as they are the persons who will badly be in need of the legal aid due to the reason that they live in indigent circumstances. They are the people with mostly unable to avail of legal aid due to poverty and penury. Therefore, a review of the right to free legal aid of the disabled people is imperative. The concept of free legal aid can be deduced from the various provisions of the Constitution of India, which came into force in the year 1950. The doctrine of equality is the basic philosophy in the preamble, and equality clause in Article 14 is available to any person in India irrespective of status. The right to life in Article 21 and the right to an arrested person to be produced before a nearest magistrate within 24 hours of arrest, and not to deny the right to consult a lawyer is enacted in the Article 22 of the Constitution are the provisions that may be cited to hold that right to legal aid is a fundamental right in India. Moreover, the Code of Criminal Procedure 1973 lays down at section 304 to provide legal aid to an accused at state expenses in case the accused is not represented by a lawyer and that the accused has no sufficient means to engage a lawyer. Such engaged lawyer at state expenses is known as amicus curiae. In the year 1976, the Constitution 42nd Amendment Act was passed by the Parliament. Article 39A was inserted in Part 4, which runs as, the state shall secure that the operation of the legal system promotes justice on the basis of equal opportunity and shall in particular provide free legal aid by a suitable legislation or schemes or in any other way to ensure that opportunities for securing justice are not denied to any citizen by reason of economic or other disabilities. After the amendment, the government of Manipur framed the legal aid scheme for the first time. The name of the scheme is the Legal Aid to Poor Rules 1976. But the scheme fell into disuse as people were not aware about the benefit under the scheme, and the situation continued till the year 1981 when the government of Manipur repealed the Legal Aid to Poor Rules 1976 and made the Manipur Legal Aid and Advice Rules 1982. The rules do not make any special provision for disabled persons. The government of Manipur Secretariat Labour Department has made another rules called the Manipur Legal Aid to Labour Rules 1987 in order to give assistance to workmen or trade union to provide services of advocates at government cost, or to pay requisite fees to an advocate appointed by workmen or by a trade union. And under the Legal Aid to Labour Rules, the legal aid may be given to all cases of claims or appeals filed by a workman or a trade union before the authorities, amongst others, before the Commissioner for Workmen's Compensation under the Workmen's Compensation Act 1923. Under these rules, a workman who has suffered permanent disablement or partial disablement arising out of and in course of employment may get his grievance of non-payment of or less payment of compensation by the employer and may be redressed by the availment of legal aid under the rules. In the year 1987, the Parliament of India passed the Legal Services Authorities Act 1987 to constitute legal services authorities to provide free and competent legal services to the weaker sections of the society to ensure that opportunities for securing justice are not denied to any citizen by reason of economic or other disabilities. The Act has now made a provision for entitlement of legal services to every person who is to file or defend a case if he is a person amongst others, a person with disability as defined in Clause 1 of Section 2 of the Persons with Disabilities, Equal Opportunities, Protection of Rights and Full Participation Act 1995. Another category of persons to entitle legal aid is a person under circumstances of undeserved want, such as being a victim of mass disaster, ethnic violence, caste atrocity, flood, drought, earthquake, or industrial disaster. A person under disability is a person who is eligible to get the benefit of legal services. He or she shall get any service in the conduct of any case or other legal proceedings before any court or other authority or tribunal, and giving of advice on any legal matter. A person having a prima facie case to file or prosecute or defend may apply to the Member Secretary Manipur Legal Services Authority or Secretary the Manipur High Court Legal Services Committee or the Chairman of the District Legal Services Authority of the district where he resides, stating the facts of the case in brief and copies of the relevant documents if any. The application should be supported by an affidavit sworn by the applicant excepting a child or a mentally ill person for whom affidavit may be sworn by a guardian. Now let us come to the judicial reaction. We have heard the Bhagalpur blinded prisoners case, which posed a notoriety of prison maladministration, police brutality, and inordinately long delay in trial of the criminal cases, resulting in a grave miscarriage of justice. There have been charges of pouring acid in the eyes of the prisoners, making them disabled persons. The cases came up for scrutiny before the Supreme Court of India in Hussain Ara Khatun and others versus State of Bihar, AIR 1979, Supreme Court 1369. Khatri versus State of Bihar, AIR 1981, Supreme Court 928, and Sukdas versus Union Territory of Arunachal Pradesh, 1986, Volume 2, SCC 401. The Supreme Court considered the issue of providing free legal services and held that an indigent accused person who is charged with an offence punishable with imprisonment is entitled to be offered free legal aid, and if he is too poor to engage a counsel, further the counsel for the accused must be given sufficient time and facility for preparing the defence. Breach of these safeguards for fair trial would invalidate the trial and conviction, even if the accused did not ask for legal aid. It is essential that an indigent litigant be provided with free and competent legal aid if the concept of equality before the law and equal protection of law is to be made a reality. In a system where the indigent has no capacity for access to quality legal services, then the adjudication would weigh heavily on the indigent person by the wealthy opponent. This would defeat the constitutional goal of equality enshrined in the preamble of the Constitution. In order to translate into practice this constitutional mandate, Article 39A of the Constitution was incorporated with an objective to provide equal justice to all and of providing free legal aid to any poor, indigent and needy person in order to overcome economic or other disabilities. A case, let us discuss. The case, namely Muhammad Azmal Muhammad Amir Kasab versus State of Maharashtra, reported in AIR 2012, Supreme Court 3565, is another landmark case which, even though not concerned exclusively the cause of the persons with disabilities, but still the law declared therein is equally beneficial to them. In case a person is accused of an offence and stood trial before a court, the Supreme Court has appreciated the position of giving free legal aid to accused persons both international and national situations, and affirm to the constitutional and statutory rights of an indigent accused to make available of the free and competent legal aid, and pointed out the duty of the trial court to provide the same, and it has been held. Every accused unrepresented by a lawyer has to be provided a lawyer at the commencement of the trial, engaged to represent him during the entire course of trial. Even if the accused does not ask for a lawyer or he remains silent, it is the constitutional duty of the court to provide him with a lawyer before commencing the trial. We now come to the aspect of judicial response to the issue of disability. The Indian judiciary had confronted with the issue of human rights of the persons with disability even before coming into force of the law entitled the Person with Disabilities, Equal Opportunities, Protection of Rights and Full Participation Act 1995, hereinafter referred to as the Disability Act. The case is D.N. Chanchala versus State of Mysore, AIR 1971, Supreme Court 1762. The issue of reservation of the seats arose for various categories of the persons and classification on the university basis. The Supreme Court, in order to uphold the human right of the disabled people, resorted to Article 15, Clause 4 of the Indian Constitution. The principle underlying Article 15, Clause 4 is that a preferential treatment can barely be given because the socially and educationally backward classes need it, so that they stand in equal position with the more advanced sections of the society. Article 15, Clause 4 states that the states are not prevented from making any special provision for the advancement of any socially and educationally backward class of citizens. The Supreme Court extended the equitable principle of preferential treatment under Article 15, Clause 4 to the persons with disability and gave opportunity of reservation of the seats in the field of education. Then comes the Disability Act 1995. The Act outlines the rights to be provided for 3% reservation in educational institutions and in government posts for disabled people. The court referred to Section 43 of the Disability Act 1995 of the Act and authorizes the appropriate governments and local authorities shall by notification to frame schemes in favor of persons with disabilities for preferential allotment of land at concessional rates for a house and others. The court ordered the state government not only to give preferential allotment of land and houses to handicapped persons, but also to provide concessional rates to handicapped persons. The court gave the meaning of rehabilitation as rehabilitation means the restoration of the disabled to the fullest physical, mental, social, vocational and economic usefulness of which the person is capable. In other words, rehabilitation is a goal-oriented program which aims at enabling an impaired person to reach an optimum mental or social functional level, which follows basically three aspects: physical rehabilitation, vocational rehabilitation and psychological rehabilitation of the disabled. The court further observed the only solution of the disability problem which a handicapped person faces could be their psychosocial and economic integration and proper placement which will enable them to stand on their own dignity and decency. In Javed Abidi versus Union of India, AIR 1999, Supreme Court 512, the petitioner contended that it was a social obligation of the airlines to provide facilities of easy access of the disabled persons, particularly those who are orthopedically impaired and suffer from locomotor disability. The reply of the respondent was that providing ambu lifts at major airports would be expensive and costly affair. However, the respondent filed additional affidavit at a later stage that ambu lift will be provided at major airports and AL chairs are going to be reserved for use by the disabled persons. Now is the time to conclude. I want to conclude by saying that some of the cases discussed above are fit cases to avail of free legal aid by the applicants, but in none of the cases the facilities of legal service was taken. Apparently, making the provisions of the legal aid requires to be made aware to the beneficiaries, including the persons under disability. Organization of the legal literacy and awareness will be required. The role of the domestic courts to implement the international norms and standards regarding the disabled people is expected. International treaties do not automatically become part of national law. However, domestic courts generally interpret statutes so as to maintain harmony with the rules of the international law. It is one of the directive principles of state policy at Article 51 of the Constitution of India that the state shall endeavour to foster respect for international law and treaty obligations is in the dealing of organized peoples with one another. If a rule of international law is not in derogation to the national law, then a court may resort to direct application of international law. And by doing so, domestic courts can play an important role in implementing international human rights norms applicable to the persons with disabilities by means of compliance with relevant international standards and citing precedents from other jurisdictions. Judicial initiatives may guide executive and legislative branches of governments to act with regard to drafting, enforcing and evaluating disability legislation. The courts may also encourage various interest groups to take up action on certain issues relating to disabled people. And this much for today. Thank you very much.